Hey everybody, Anthony the crypto lawyer here, and we have some great, exciting news to talk about today. The long awaited order in the SEC versus Ripple Labs case was recently announced. I have not read it, but I want to go through it, and I want to go through it with you so we can convert the legalese into plain English for folks that might not understand what it is actually happened. We're going to go through it basically page by page. It's a long opinion, I think, and this will be a multi-part video. So let's just go ahead and go through it. So this is going to be exciting. Okay, so here we are. I got this pulled up. I got this through a website called Pacer, which is how attorneys get the pleadings or the documents in any particular federal court case. So you can always sign up to get this account and search records yourself. This is the case number up here, obviously. So that would be a good place to search. I'm sure this document's online somewhere. It's probably been shared 1,000 times by now, so you can find it. I just can't get past the lawyer habits that I have. So okay, so we have SEC against Ripple Labs, Brad Garlinghouse, and Christian Larson. This is an order. This was filed yesterday. Look at that. All right, so let's go through it and let's see what Judge Torres has to say. So the first paragraph here is just typically a summary of sort of what has happened and what ultimately, this is the spoiler alert right here, essentially. So let's go through it. Plaintiff, the Securities and Exchange Commission, SEC, brings this action against defendant Ripple Labs and two of its senior leaders, Bradley Garlinghouse and Christian A. Larson, alleging that defendants engaged in the unlawful offer and sale of securities in violation of Section 5 of the Securities Act of 1933. That's all pretty self-explanatory. The SEC also alleges that Garlinghouse and Larson aided and abetted Ripple's Section 5 violations. Sure, okay. But before the court are the parties' cross motions for summary judgment. Now, a motion for summary judgment, for those that don't know, is a motion that essentially says, hey, we don't have any facts that are in dispute, so we don't need to go to a trial in front of a jury or in front of the court. So you should just, judge, go ahead and decide the issues right now on the basis of our written briefs, which usually are not brief. They're very long documents. And a lot of people don't understand that. When I talk to my clients about this sort of stuff, they don't understand that you're not really always going to want or need a jury trial or a bench trial. Trials are typically done only for the basically resolving disputed facts. So apparently the parties decided that they didn't really have disputed facts in this case. Both of them thought as much because they both filed their own cross motions for summary judgment. So let's see what else. For the reasons stated below, the SEC's motion is granted in part and denied in part. And defendant's motion is granted in part and denied in part. That basically means that there were some parts of the arguments that the SEC made that the court agreed with and disagreed with, and vice versa for the defendants, which whenever you hear reference to the defendants, we're talking about Ripple Labs, Christian, and Brad Garlinghouse and Christian Larson, sorry. So that's what's going on. Basically, the court did not find in favor of one side or the other totally. So we're going to have to go through this and find out what's good and what's bad. But from what I hear from other folks, it's mostly good for Ripple. So let's go through it. Footnote 1, portions of the briefs, Rule 56.1 statements and other documents discussed in this order were filed under seal or redacted. So that means that there were things that are confidential that we will probably not be able to look at or pull up. So the court is relying on things that the court has seen that we have not seen or will not be able to see. ECF number 819, that's just a reference or a citation to a particular filing that was made with the court. So when parties want to give something to the court officially, they file it, and it's affixed with a particular identifying number. Usually it goes in order in the federal court system. So ECF number 1 is usually the very first document that's filed in the case, and so on and so forth. So the second document is number 2. Okay, and these are case citations. So whenever you see these italicized words here, this is like the first party in the case versus who's the plaintiff usually versus the second party in the case is the defendant. And then this is all stuff lawyers use to find that particular case in the annals of the law library. So, which is now mostly online. But this is all important stuff. But we can go through that if it becomes important. But essentially, she's just relying on these particular cases to support this previous sentence right here. Okay, which is not particularly important in this footnote. The materials are judicial documents because they are relevant to the performance of judicial function and useful in the process. That's basically saying that she was allowed to look at those documents. It's all very complicated stuff, but if we need to, we'll go through it. So to the extent that the information in these documents is disclosed in this order, the privacy and business interests that justified their sealing or redaction are outweighed by the public's right of access. She's saying these are things that that although they are supposed to be private, there might be some things in there that, or excuse me, although there are some things that are disclosed in this order, there are some things that might be sealed or redacted, and they are outweighed by the public's right of access to information. Oh, no, gosh, I'm getting it up backwards. See, this is confusing for me too. So there might be confidential documents that she has disclosed parts of things because we as the public have a right to see that information in order to understand the basis for the court ruling. So that's what she's saying there. It's essentially a notice to the parties that although they wanted some things to be hidden from us, the court decided it was more important to let us see that particular information. So, okay, anyways, background. Here we go. This is where they go through a lengthy history of what happened. And this is important for an understanding of how we're going to get to the court's analysis. So typically the courts want to lay out the factual foundation for everything first so that we can follow along with the court's reasoning and we can understand why the court is issuing what they're issuing with this ruling. Also, and I'll get to this later, this is probably going to be appealed. I don't even have to read this court ruling, and I already know this is going to be appealed. And the reason for that is because this is a ruling on a matter of law, meaning that this trial court has decided an issue that has to do with the law or an interpretation of a statute or some rules. Or I know in this case she mentioned that she's going to be interpreting the Securities and Exchange Act of 1933 or whatever. So the Securities Act of 1933. So that means that she came up with a particular interpretation of that law, and the Court of Appeals might disagree or might come up with an alternative interpretation. So we know whoever is going to be considered the quote unquote loser in this case is going to appeal this. So I wouldn't be surprised if we see a notice of appeal today, tomorrow, in the next few days. And, I with 90% certainty can tell you that this case is going to be appealed. So don't be surprised when it comes. It's inevitable. Okay. This was a huge, huge ruling, and the person in this case, probably the SEC, who's not feeling very great about it, is going to want a second bite at the apple. So this factual background is important for the Court of Appeals to understand what's going on, because they will get something called the record, which is just the written portions of what happened in the lawsuit itself that the parties deemed to be important for deciding the issues. And that's going to include this factual background. So let's go through it. All right. Development of the XRP ledger and the founding of Ripple. And this is all fascinating stuff anyways, so let's just go through it. In 2011 and early 2012, Arthur Brito, Jed McCaleb, and David Schwartz developed the source code for a cryptographically secured ledger, or a blockchain, which is now known as the XRP ledger. Footnote 3 says, a blockchain is an electronically distributed database, or ledger, shared among a computer network's nodes. C. Adam Hayes, Blockchain Facts. What is it, how it works, and how it can be used? That might be an interesting book to read. I might get that. Oh, actually, looks that's an Investopedia article. Okay, I'll read that also. A blockchain is a system for recording information. Each transaction is recorded as a block of data on the digital ledger, which is connected to the blocks before and after it. Blockchains are typically recorded across a distributed network of computers. If you are a crypto fanatic, you know that already. So let's move on. SEC 56.1, response, section 11, ECF number 842. So this is referring to a particular filing that was done by the SEC, and this is the specific place where that citation is pointing to. Paragraph, that's a paragraph symbol, paragraph 11. So whenever you see these like weird letters and numbers and some what appears to certainly be some sort of citation, it's always in reference to the sentence that's right before it. So that might be important later on when we get through some of this. So, okay. They aimed to create a faster, cheaper, and more energy efficient alternative to the Bitcoin blockchain, the first blockchain ledger, which was introduced in 2009. Cool. ID is shorthand for saying the same citation that I referred to in the immediately preceding sentence, or the most recent citation. I'm just repeating it. So that's what ID means. If you see that, that's it's Latin for something I don't really know or remember what that is. And these are paragraph symbols, so that's just giving you specific paragraph citations. It's so that lawyers can go quickly to a particular sentence instead of having to read an entire case like we're doing right now in order to find out what people are talking about. Okay, when the XRP ledger launched in 2012, its source code generated a fixed supply of 100 billion XRP. Yeah, I remember that. That was a lot at the time. Well, not in 2012. I got into it in 2017, but people were still talking about why that was a lot. XRP is the native digital token of the XRP ledger, and the XRP ledger requires XRP to operate. It's good news for the XRP folks that have always had questions about that. Each unit of XRP is divisible into 1 million drops, so the equivalent of Satoshis for those that are not XRP nerds. And each unit or drop of XRP is fungible with any other unit or drop. Okay, again, we have some citations. In 2012, Brito, defendant Larson, and McCaleb founded Ripple. Interesting. Let's look at footnote 4 right there. Boom, 4. Ripple was originally named Newcoin Inc. Wow. And incorporated under California law. That's fascinating. It was then renamed OpenCoin Inc. in October 2012. I remember, I've heard that. In 2013, the company was renamed Ripple Labs Inc. Good choice. And in 2014, it was incorporated under Delaware law. In this court, the court shall refer to the company as Ripple, even when referring to its forerunners, Newcoin and OpenCoin. Great. That will just make it easier for us to understand, and letting everyone know the court is just understands that there were previous company names, but she doesn't want to confuse us by referring to Newcoin and OpenCoin, and it all can get very confusing. So she's just going to refer to everything as Ripple. Okay. Larson became Ripple's CEO, a position he held until December 2016. Of the 100 billion XRP generated by the XRP ledger's code, the three founders retained 20 billion for themselves, including 9 billion for Larson, and provided 80 billion XRP to Ripple. Okay, so what does that mean? So XRP's ledger had 100 billion XRP that was created. The three founders, so was it Brito, McCaleb, and Schwartz? Oh, no, just kidding. Brito, Larson, and McCaleb, so the three founders, retained 20 billion for themselves, including 9 billion for Larson. So Larson kept 9, and the remaining 20 billion was split between Larson, McCaleb, and Brito. Okay, so that's a lot of XRP. And they provided 80 billion XRP to Ripple. So this could be important because how the XRP was given to Ripple originally has always seemed to come up in people's discussions. So Ripple had 80 billion XRP. Okay. The founders did not sell any XRP before the launch of the XRP ledger, and Ripple never owned the 20 billion XRP retained by the three founders. Okay. The fact that she's even discussing this seems to suggest to me that this is going to be important later on. So let's understand this a little bit more. The founders did not sell any XRP before the launch of the XRP ledger. Okay, they probably couldn't. There wasn't a market for it. And Ripple never owned the 20 billion XRP retained by the three founders. Okay, so they're setting it up to say that they were separate. Okay, whatever the founders had was not given to them by Ripple. It was just something that basically appeared upon the XRP ledger and was immediately bestowed upon the founders. Ripple did not even touch the 20 billion XRP. Even if they had touched it, they never, quote unquote, owned it. Okay, and that's going to be an important distinction, I'm sure of it. Okay, since its founding, Ripple's mission has been to realize an internet of value by using technology to facilitate the transfer of value across the internet. Yeah, that's pretty cool. Okay, specifically, Ripple seeks to, quote, modernize international payments by developing a global payments network for international currency transfers. And if you don't know anything about that, you're missing out because it's super cool. And yes, I do like XRP for that reason. Okay. For instance, Ripple developed a software product called RippleNet, which allows customers to clear and settle cross-border financial transactions on mutually agreed upon terms. Yeah. One feature of RippleNet is known as on-demand liquidity, ODL. It also had a number of other names in the past, like Ripple. I think it was like X Rapid or something. I don't remember, but it had other names for ODL. So this is what they're talking about. If you're one of the OG XRP holders, I think we're talking about X Rapid here when they talk about on-demand liquidity. Okay. ODL facilitates cross-border transactions by allowing customers to exchange fiat currency, for example, US dollars, for XRP, and then the XRP for another fiat currency, for example, Mexican pesos. And it all happens very quickly. Like ODL, some, but not all, of Ripple's products and services rely on the XRP ledger and XRP. The XRP ledger is based on open source software. Anyone can use the ledger, submit transactions, host a node to contribute the validation of transactions, propose changes to the source code, or develop applications that run on the ledger. Other developers have built software products that use the XRP ledger, such as payment processing applications. Ripple has also funded companies as part of its Spring, whatever it's, however that's pronounced, Spring initiative to incentivize the development of other use cases on the XRP ledger. Okay. Use cases. I think that's not a particular, that must be like a crypto term or something. Okay. Defendants, sales, and distributions of XRP. At all times before the end of 2020, Ripple owned between 50 and 80 billion XRP. Although the parties dispute the specific dollar amounts and details, they agree that from 2013 through the end of 2020, Ripple engaged in various sales and distributions of XRP. Okay, so the parties agree that from 2013 through the end of 2020, Ripple engaged in various sales and distributions of XRP. That's important, right? Because that's what's in dispute. First, Ripple, through wholly owned subsidiaries. And for those that don't know, a subsidiary is just a company that is owned by another company. And the company that one company is owned by is usually called the parent. And the company that is owned is called a subsidiary. So Ripple, through wholly owned subsidiaries, meaning other companies that it owned, sold XRP directly to certain counterparties. Counterpart Counterparties is just a fancy word for saying someone else that is important to the transaction. So the counterparty in a buy-sell relationship would be the buyer, because the seller is selling an item to a counterparty, aka the buyer. So this is just fancy attorney talk. It's unnecessary. But anyways, okay, so XRP directly to certain counterparties, primarily institutional buyers. So that's probably meaning banks, just other credit unions or whatever, just big name players is what institutional buyers means. It's a fancy way of saying not the little people like us. Okay. Hedge funds and ODL customers. And ODL customers, primarily probably money transfer folks, like maybe MoneyGram at some point had a relationship with Ripple, and they transmit money and do the same thing that ODL basically does. But so that's probably what it's referring to. So banks, hedge funds, ODL customers, money transmitters. Okay, pursuant to written contracts, which will from now on be referred to as the institutional sales. So all of these transactions are going to be referred to as the institutional sales. Okay, and again, we have a bunch of citations. We're probably not going to see that. You could go through this in great detail and go to, the SEC's response, defendant's response, and, you could track all this stuff, but I'm not going to do that, at least not today. That's a lot of work. Okay, the SEC alleges that Ripple sold approximately $728.9 million of XRP in these institutional sales. That's actually not that much. In the grand scheme of crypto, that's less than $1 billion worth of XRP. I mean, it's a lot for us, obviously, us retail consumers, but we're talking about less than $1 billion of XRP that is apparently at issue. Okay. Second, Ripple sold XRP on digital asset exchanges programmatically. I'm actually interested to know what this means. Or through the use of trading algorithms, the programmatic sales. Okay, so Ripple sold XRP on digital asset exchanges programmatically. I've never really understood that, but I guess that just means they had it on automatic pilot, that they were going to sell this, when the sale dumped, they would buy, and if they would, I guess Ripple sold XRP only. So we're just talking about the sales. Okay, so when the price would get really high, they would sell some immediately. Great, now we know why the price never went super high, I guess. Okay, Ripple's XRP sales on these digital asset exchanges were blind bid-ask transactions. That's good. Ripple did not know who was buying the XRP, and the purchasers did not know who was selling it. So very likely, maybe we had bought some from Ripple. Possible. Okay, we have more citations. The SEC alleges that Ripple sold approximately $756 million of XRP in programmatic sales. Okay, so we have 728 million of institutional sales and 757 million in programmatic sales. So now we're talking about roughly $1.5 billion of XRP sales. Okay, that's more. That's a bigger number. It's almost double what we were talking about before. Ripple used the proceeds from the institutional and programmatic sales to fund its operations. Okay. It's a business. Why not? Okay. Ripple also distributed XRP as a form of payment for services, other distributions. Okay. So, yeah, for instance, let's just read it. Well, actually, let's see. There's a footnote 5 here. Since 2012, Ripple has also raised investment capital through multiple funding rounds in which it sold stock to investors. That's very classic. Okay. Ripple has issued millions of shares of common stock, as well as convertible notes, preferred stock, and a stock warrant. Gosh, I wish I could buy some right now. Their stock price is probably going to shoot up after this, but I'm not in the club. I guess, that has access to any of these IPOs or private funding rounds. Maybe one day. Okay. For instance, Ripple also distributed XRP as a form of payment for services, other distributions. For instance, Ripple distributed XRP to its employees as a form of employee compensation. Okay, the same thing as you getting stock options from your company if you work at like Walmart or something. So they said, hey, instead of giving you cash, would you accept XRP? And people said yes. So then they just gave them XRP instead of cash as at least part of their compensation for working there. Okay. I'm sure that was an option and not a requirement, but who knows? Okay. Ripple also distributed XRP in conjunction with its Spring initiative to fund third parties that would develop new applications for XRP and the XRP ledger. Okay. In sum, the SEC alleges that Ripple recognized revenue of $600 million from its distributions of XRP to individuals and entities in exchange for services. Okay, so in addition to the 1.5 roughly billion, they're saying that Ripple recognized revenue of 609 million from giving XRP to folks in exchange for services and for other stuff. So now we're talking about roughly $2.1 billion of money that's at stake, or value that's at stake. Okay. Footnote 6. We have a footnote 6 here. I like to read these in order. Some people like to read them at the very end, but I like it to flow. Okay. Ripple also distributed XRP for free to early adopters and developers, and to charities and grant recipients. That's really cool. I did not know that, but that's nice. The SEC does not include these transactions in its complaint. Well, they better not. I mean, they're already being kind of dickish with how they have been treating Ripple. So here we go. In addition to Ripple's sales and distributions, Larson and Garlinghouse offered and sold XRP in their individual capacities. Okay. They're human beings. What's the problem with that? Okay. After stepping down as CEO of Ripple in December 2016, Larson became the executive chairman of Ripple's board of directors, a position he currently holds. From at least 2013 through 2020, Larson sold XRP on digital asset exchanges programmatically, and so with trading algorithms and stuff, and he made at least $450 million from his sales. Wow. Wealthy guy. That's really cool. Nothing wrong with that, by the way. I only wish I could be as rich as that, but yeah, good for him. Garlinghouse was hired as Ripple's COO, or it's probably Chief Operations Officer, in April 2015. After Larson stepped down as CEO, Garlinghouse became CEO effective January 1st, 2017, a position he currently holds. From April 2017 through 2020, Garlinghouse sold XRP on digital asset exchanges. The SEC alleges that Garlinghouse sold approximately $150 million in XRP during this period. Cool. That's great. Making money. Garlinghouse also received XRP as part of his overall compensation from Ripple. Fine. Just like the employees. Defendants did not file a registration statement as to any offers or sales of XRP. Now, that's going to be a main issue in the case. I'm sure of it. Ripple did not publicly file any financial statements or other periodic reports, nor did it make any EDGAR filings. EDGAR, I'm not a securities and exchange lawyer, but I'm pretty sure that EDGAR is the system that is used to make filings, like required filings, like uploading quarterly statements or whatever. Okay, here we go. It actually has, here we go, footnote 7. So you don't have to worry about my recollection. She'll explain it. EDGAR, or Electronic Data Gathering, Analysis, and Retrieval, is an electronic filing system developed by the SEC to increase the efficiency and accessibility of corporate filings. Okay. Easy. Okay. So they did not make EDGAR filings with the SEC for Ripple or XRP, such as a Form 10Q which I think is a quarterly statement. Don't quote me on that. Form 10K, Form 8K relating to XRP. Those are things that securities lawyers would know about. I do not. Okay. All right, defendants' XRP marketing campaign. The SEC alleges that in 2013, defendants began extensive years-long marketing efforts representing they would search for purported use and value for XRP. Okay, let me read that again. In 2000, began extensive years-long marketing efforts representing they would search for purported use and value for XRP and casting XRP as an opportunity to invest in those efforts. Okay, so defendants, meaning Ripple, and Brad Garlinghouse and Christian Larson, they were on the hunt for different discoveries that could be had to use XRP, and they just said, hey, you can invest in XRP and join us in that venture. Okay. The SEC, well, let me be very specific, did not join us in that venture, just saying, hey, we're doing this. You can invest in those efforts. By the way, I was not present for any of those, so this is just my interpretation. All right, I don't know those people at Ripple. Okay, the SEC points to a wide range of statements, including informational brochures, internal talking points, public blog posts, statements on social media, videos, interviews with various Ripple employees, and more. Okay, defendants dispute the SEC's factual narrative, and okay, so this is what the SEC was saying that Ripple was doing. Okay, so they're saying, "Hey, why don't you join us in trying to invest in XRP?" Okay, this is what defendants dispute that. So Ripple disputes the factual narrative and argue that SEC cherry picks excerpts from documents with many authors and from public statements of many speakers made at many points across an 8-year period of time to many audiences. That's a great line. That's good. I like that. Okay. Since at least 2013, Ripple has prepared. By the way, the fact that there was a dispute about the factual narrative, I mean, that could have thrown out potentially the usage of a summary judgment motion in the first place. And that, if that was something that was important, it might have been kicked to a trial. So I don't know how. Let's see where that goes. Okay. Since it might be obvious from she might get around it by saying that, listen, it's obvious to her. We'll see. Okay, since at least 2013, Ripple has prepared and distributed documents that describe the company's operations. I mean, by the way, let me go back to that. She's probably seen all of these things. Like, this is all facts, I'm sure, have been attached to the summary judgment motion. These speaker transcripts and the informational brochures and internal talking points. I'm sure she's had an opportunity to look at all that stuff. So, okay, let's go back to it. Since at least 2013, Ripple has prepared and distributed documents that describe the company's operations, the XRP trading market, and the XRP ledger. For example, in 2013 and 2014, Ripple created 3 brochures: a Ripple for Gateways brochure, a Ripple primer, and a deep dive for financial professionals. Okay, those are cool. I've never seen any of those, but that looks cool that they did that. I mean, what other blockchain cryptocurrency company does that? I don't know. These documents were distributed publicly to prospective and existing XRP investors and outline, among other investors, and outline, among other things, the relationship between XRP and Ripple's business model. So they gave information to folks about some of this stuff and what they thought the business model would be and their thoughts on it. Okay, Ripple circulated versions of the Gateways brochure to more than 100 third parties. Okay, to more than 100 third parties. The primer had widespread distribution. Okay, so the Gateways brochure was really given to a select number of people, 100 people. Okay, the primer had widespread distribution, so probably a way more than that. And the deep dive was posted on Ripple's website and sent to over 100 people. Again, that's not really that many people if you think about it. Okay. But so it must be the primer that had the quote widespread distribution. All right, later, starting, is there any more? Okay. Let's see. Oh, okay, here we go. This is footnote 8. The SEC's Rule 56.1 statement contains over 1,600 purported facts, many of which are disputed by the defendants, and cites over 900 exhibits. The court highlights below only those documents and statements directly relevant to this order. That's interesting because, again, the fact that the facts are disputed would suggest to me that, this might not be good for an order on summary judgment. But maybe she just found that the facts that were important to her order were not disputed, and the disputed facts are just irrelevant. So I don't know. We'll see, because that's always a big question in a summary judgment motion. In fact, I'll be writing a reply to one of those later today in my own case. Okay. Later, starting at the end of 2016, Ripple began to publish on its website quarterly XRP market reports, which were intended to provide clarity and visibility about Ripple's market activities. And I remember when those came out, or at least not in 2016. I remember in 2018 when I saw my first one that I thought, wow, this is super cool. Like, that seems very professional. I hadn't seen any other blockchain, group issuing anything like that. So I thought it was very professional at the time. One of the reasons why I liked XRP. Okay. Ripple and its senior leaders used a variety of social media platforms, including Twitter, Facebook, Reddit, and XRP Chat, an online forum described as the, quote, largest XRP crypto community forum, to communicate about XRP and Ripple. Twitter, Facebook, Reddit, and XRP Chat. I don't know XRP Chat. Okay. Maybe I'll look it up. Ripple officials also spoke in interviews about the company and its relationship to XRP. For instance, Larson gave interviews in which he discussed XRP. Again, these are just citations. That's what all this gobbledygook looks like here. That's all citations. And Garlinghouse was interviewed by media outlets such as the Financial Times, Bloomberg, and CNBC, spoke with organizations like the Economic Club of New York, and participated at conferences such as DC FinTech, in which he described Ripple's operations and the XRP market. Cool. Defendants' receipt of legal advice about XRP offers and sales. In February 2012, before the XRP ledger was publicly launched, Ripple's founders, including Larson, received from the Perkins Coie LLP law firm a memorandum. Perkins Coie is a big law firm. I mean, these guys are huge. So whatever they put in that memorandum is probably something that Ripple would have felt comfortable relying upon. Okay. Received from Perkins Coie law firm a memorandum which sought to, quote, review the proposed product and business structure, analyze the legal risks associated with Ripple, and recommend steps to mitigate these risks. By the way, I don't know what it said here originally, but it should be noted that there was some dispute at some point about what XRP was called, because I think they used to call it Ripple, and the company name was Ripple. And so there was some confusion there. And then they separated it into XRP, or they changed the name from Ripple to XRP. And that's why a lot of people still call it Ripple, even though it's supposed to be called XRP now. I mean, they just declared that it's called XRP. So folks were already a little bit confused by that. But I imagine that's why this is in brackets here. Anyways, let's move on. The memorandum analyzes, among other things, the legal risks associated with selling XRP. Specifically, it states that, quote, if sold to investors, XRP tokens are likely to be securities. And, quote, to the extent that the founder's issuance of XRP does not involve an investment of money, there is a low risk that XRP will be considered an investment contract. Okay, let's read that again. If sold to investors, XRP tokens are likely to be securities. That's not good. I mean, that is not good. I mean, that's saying if you're selling it to an investor, like someone who comes to you and wants to like partner with you or whatever. Okay, so that's saying that, hey, if you do certain kinds of activities, it could be a security. And, quote, to the extent that the founder's issuance of XRP does not involve an investment of money, there is a low risk that XRP will be considered an investment contract. So I guess how I'm interpreting that, and again, I'm not an SEC, securities lawyer, but if you are receiving money, if Ripple is receiving money from investors in exchange for XRP, that could be considered the same thing as like receiving stock, like that is sort of how Perkins Coie kind of concluded in their opinion. But if you're just selling it to the public, and it's not really an investment situation, and you're not like getting involved in investing with the public or whatever, then it's not going to be considered an investment contract. And that's the whole question about this case: is was XRP a security or was it not? And if it was a security, there's a whole host of reporting requirements that need to take place. You need to like create specialized pro forma statements that cost a crap load to create. And I mean, you have to like basically communicate very frequently with the SEC, and there's all this stuff. I'm not a securities lawyer, but that's my understanding. So it's a big deal if it's an SEC, if it's considered a security, because that also determines how banks and other folks can interact with XRP. So that's why it's a big deal. Okay. In October 2012, Ripple, Larson, and others received another memorandum for Perkins Coie, which sought to review the proposed features of the Ripple network and XRP to provide recommendations for mitigating relevant legal risks. So let's figure out how we can not get sued by the SEC or anyone else. That's what that means. That memorandum states that although we believe that a compelling argument can be made that XRP tokens do not constitute securities under federal securities laws, given the lack of applicable case law, we believe that there is some risk, albeit small, that the SEC disagrees with our analysis. Okay, that means that, hey, we really think that XRP is not a security, but we cannot guarantee you that the SEC will disagree and find otherwise. So it's essentially a disclaimer saying, hey, this is what we think, but it might not be what the SEC thinks. Okay, sure. The memorandum further states that the more that the founders of Ripple promote XRP as an investment opportunity, the more likely it is that the SEC will take action and argue that XRP tokens are investment contracts. I think that's pretty self-explanatory. It's basically saying, hey, if you keep holding this out there as if it's, we'll give you XRP in exchange for you investing in our company, then it's going to be, the SEC might view all of XRP tokens as investment contracts, the same thing as stock, for example. That's like the classic security example. Larson reviewed both the February and October 2012 memoranda and discussed them with Perkins Coie attorneys. Both memoranda analyzed XRP under the Supreme Court's holding in SEC versus W.J. Howey Co., which is where the Howey test came from, I presume, a U.S. Supreme Court case from 1946. That's how you read this. That's signal language. U.S. is that just means Supreme Court case decided in 1946. Okay. Which outlines the standard for an investment contract, right? That describes the test that is used for an investment contract. I'm sure that will be the centerpiece of this decision. So, okay, so we've only gone through 8 pages. This is the factual background of this case. I'm surprised there was not more. I thought this is going to be quite a lengthy factual summary, but it wasn't as big as I've ever seen it. So, okay. So that's where we're at now. I'm going to probably end this video here and start a new video going through the procedural background. And I think that just makes sense because we've been on here for quite some time. And stay tuned. I'll have another video going through the procedural background. That'll be more dry. But But if folks find that interesting, I am confident that I'll be able to make it at least a little bit more exciting with my insight as a lawyer to explain some of this stuff. So stay tuned. All right, folks. Thanks.